of the reality on ground. Please, another round of applause for our discussant. We've really enjoyed his contributions to the lead paper and analysis, practical experiences. Well, we welcome learned son, Mr. Audu Anuga. You are most welcome. We understood why you are not here long before now. We are happy to have you. And we started a bit late, so we are running behind schedule. But we are ready to have you, to take you on now, if you are prepared for us. And I'm sure you are prepared because I already have an advanced copy of your paper. So please, so that we can have time for interactive session, questions and answers and comments, we give you 10 minutes. And if you need it, I'll give you extension of time of 1 or 2 minutes.
Thank you, Mr. Chairman. Thank the lead presenter. And I do apologize that I had been late. It was due to circumstances beyond my control. You know, as lawyers, we normally have to adhere to whatever directions that the courts give us. And I was actually in compliance with one of those directives. I've had the privilege of the lead presenter's paper. I've considered it. My paper basically doesn't do more than re-echo what was in the lead paper. So I will just skip to basic highlights, and I will go through as much as I have presented. Now, I did hear that I was well presented for the okay. I don't know about being well prepared for this. I think we can't be better prepared than the lead presenter who has been in these trenches regarding this matter and has led the bar enviably in its protection regarding the duties we owe to confidentiality to the clients. I believe that as a legal profession, as the tradition entails, if you eliminate that aspect from the profession, I think we'll be doing nothing different from whatever the usual professions on the street are doing. Our calling spans centuries and ages. If you read Cicero was a lawyer. And if you read about his life and his career, you find out that we're beholden to a tradition that has lasted for centuries. So if it comes to this generation and our time, I believe that what we do owe the profession, at least, is to support the tradition as we have met it. If we can't improve it, at least let no element of it that has been handed over to us be missing. And a critical element of that is confidentiality. So I will just start basically by saying that the current regime indicates a slight tension between the anti-money laundering regulations and the legal profession's duty to confidentiality. And this has sparked a significant debate that has engendered this gathering that we have today. And we believe that this will provide us an opportunity to find a roadmap to deal with this question. Now, while recent amendments to the Money Laundering Act, particularly Section 11.4, clearly state that the Act applies to lawyers regardless of any confidentiality obligations, this has led to concerns within the legal community, as I've highlighted earlier. Now, in the recent High Court decision of Abu Arome versus Central Bank unreported, delivered on the 19th July 2024, the court had the opportunity to examine the issue. And despite the legislative changes of the MLA 2022, the court chose to reaffirm the decisions of the Court of Appeal in CBN versus Registered Trustees of the Nigerian Bar Association that the MLA cannot override confidentiality essential to the legal profession as encapsulated under the provisions of Section 192 of the Evidence Act and Section 20 and 21 of the Legal Practitioners Act and Rule 19.1 of the Rules of Professional Conduct 2023. I provided the citation of those decisions in the paper that I had shared earlier. Now, my paper basically delves into the complexities of the application of the MLA to the legal practitioners, examining how judicial interpretations have consistently upheld attorney-client confidentiality against regulatory incursions, as well as the critical analysis of the provisions of the rules 55 to 72.2 of the RPC 2023. Now, basically, what the analysis considered were the Money Laundering Prevention and Prohibitions Act 2022, the Legal Practitioners Act, Evidence Act 2011, Rules of Professional Conduct for Legal Practitioners 2023. Now, there is, as we had considered, an intersection of the legal practice and anti-money laundering regulations, and we consider the cases that have looked at this. We considered the CBN versus Registered Trustees of the Nigerian Bar Association, who provided the citation. Now, this particular case basically challenged the application of the Money Laundering Act, especially sections 5 and 25, which classified legal practitioners as designated non-financial institutions and imposed compliance requirements on legal practitioners. The case also looked into that legal practitioners, the inclusion of legal practitioners as designated non-financial institutions. The court had held that due to the extensive regulatory requirements already governing the legal practice, subjecting lawyers to additional designated non-financial institutions obligations under the Money Laundering Act, those provisions were basically unnecessary. It also noted that only the Supreme Court could revoke lawyers' licenses under the Legal Practitioners Act, and that the regulatory provisions seeking to also deprive lawyers of those of that privilege were in conflict with the principal legislations that actually provided for this. The court chose to apply the blue pencil rule and found that the legal provisions, the relevant provisions that try to impose a designation of non-financial institution upon legal practitioners, it used the blue pencil rule to strike down those provisions. One of the things that we note, and we commend the lawyers who handled the matter, was the fact that the Court of Appeal had the opportunity to consider the decision of the trial court in this regard and upheld it. The Court of Appeal had underscored that any intention to subject legal practitioners to those regulations would require explicit regulatory language, which the Court of Appeal had considered to have been absent. Another decision of the Court of Appeal that looked into this question is FRN versus Chief Mike Ozekome SAN. Now, in this case, a legal practitioner whose firm's account had been subjected to an interim restriction order filed a motion to set aside the order, arguing that practitioners are excluded from the definition of designated non-financial institutions under the Money Laundering Act, and that lawyers have no duty to investigate the source of a client's funds used to pay their professional fees. The Federal High Court granted the application and lifted both the interim order and the restriction on the lawyer's account. There was a challenge to the trial court's decision. The appellant appealed to the Court of Appeal. The Court of Appeal, affirming the trial court's decision, relied on its decision that had earlier highlighted and considered to hold that the provisions of the Money Laundering Act were inapplicable to legal practitioners. The court further stated that a legal practitioner is entitled to his fees for services rendered, and such fees cannot be classified as proceeds of crime. It emphasized that the law does not require lawyers to investigate the source of a client's funds used to pay them. So basically, The position we're considering currently is a response to the prior court's decision, excluding legal practitioners from the application of the said provisions of the Money Laundering Act. So the Money Laundering Act 2022 was enacted to include a new section 14.4, stating that the obligations under those provisions apply to lawyers and nullifying lawyer-client confidentiality in specified transactions. Additionally, Section 30 redefined legal practitioners and notary publics as requiring them to register with the SCOMEL and complying with the reporting and record-keeping obligations. So basically, what my paper looked at basically what was in the main paper. I did not depart from it. What I did was to consider the position from time immemorial and international positions that have actually confirmed this position. We believe and take the view that confidentiality is intrinsic to the provision of legal services. And once that component is eliminated, that it will be quite difficult for legal service to be provided in the manner in which we recognize it. I do believe that the provision of legal services is constitutional. The services we provide are constitutional in nature, have been recognized by the Constitution, and any effort to erode those rights would be unconstitutional in nature. I do believe that if there is a duty and an obligation to deal with the question of money laundering, this can be done, and methods should be found to achieve this without curtailing existing rights that enable us to provide legal services. So those are my positions. Thank you, sir.
Thank you, thank you. That's another good presentation. And it was the discussant did the discussion within the time limit.
Thank you very much.
We thank you for that good and acid presentation. Now, we've come to a stage. Let me allow him to sit down and settle down. And for honoring us, I want us to honor him with another round of applause. Thank you so much. At this point in time, I will call my son, Paul Babatunde Daudu San, to come and assist me with the interactive session and particularly the online participants who are in Glass House.
Thank you. Let's give Mr. Chairman and our resource persons a round of applause. We go to the interactive session. So I will start with the secretariat here, while Mr. Audu, I think somebody's broken our camera. Yes, Mr. Audu should prepare for interventions over there in LOKOJA. So at this point in time, we'll take interventions, just like we did yesterday. If you have a comment, restrict your comment, please, to 2 minutes. And if you have a question, please, 1 question at a time. One person should not take 3 or 4 questions. If you have other questions, we have the networking sessions. You can still interact with the resource persons during the tea break. But so just 1 question, and if you have a comment, please restrict yourself to 2 minutes. So I don't know if we have any questions or comments from the secretariat. Does anybody have any intervention? Okay, my lord. My lord, we'll take my lord. Anybody else? Let's start with my lord first. My lord enjoys judicial immunity. So
all protocols duly observed. My question is on Rule 60, sub 3 of the 2020 rules of the RPC, which provides, which imposes a duty on a lawyer to immediately identify and freeze without prior notice all funds and any other economic resources belonging to the designated person or entity. Even though the presenter has earlier said that this provision of the rule is in conflict with Section 36 of 5. So my question here is, how can a lawyer impose freezing of an account or money with his clients? Is it going to be is he going to in conjunction with the police, or how is he going to do? How is he going to enforce this provision of the law? This is my question.
Thank you very much, my lord. I'm sure the resource persons have noted that question. The question is on the obligation of legal practitioners now under the rules of professional conduct 2023 to withhold assets, funds of clients, whether it's by court order or by legal practitioner order. We know how we do it. Yes, Chinelo. Can we take Chinelo? Abdul, please, do we have anybody in LOKOJA? Please.
Thank you very much. All protocols duly observed. Mine is a question to Mr. Arome, and it's on rule 71.1 of the RPC 2023. Because a lot has been said about how the rules of professional conduct as amended is only for internal regulation of the bar. But that particular provision mandates that when a lawyer files suspicious transaction reports, the MBA AMLC will transmit that report to the NFIU. So in a way, what it has done is that it has created a longer bridge from what was done in MLA that required you to report straight to SCUMO by just adding the MBA as a bridge between the state and the legal practitioner. As now the MBA will now have to be the ones to report you. But regardless, it is a misconduct if you don't submit it to the AMCA. So is it still about internal regulation, or is it just a way of putting MBA in between that's what was created before? Thank you.
I think the point has been noted. Is MBA now, is the buck being passed on to MBA in terms of reporting obligation, or is it about self-regulation? Can we take LOKOJA now? Yes, Abdul, can you hear me? We can't hear you. Unfortunately, we can't hear you here. Unfortunately, I cannot hear you.
Can you hear me now, Lenesik?
Yes, it's better. It's better. I can hear you now.
Okay, thank you. We have a contributor.
Please, okay.
Okay, my name is Dr. Chris Balogun. I just want to appeal to the convener to just please grant me these 3 minutes so that I can give my intervention better.
I rule you out of order. You're not a legal practitioner, sir.
I know, no, but what I want to say is that, you know, it has to do, I don't have to be
restrict yourself, Mr. Balogun, restrict yourself to the conversation.
Okay, sir, what I'm just saying is that there are some things that just require common sense to look at it. Me, I will advise the ICPC and the FCC to strengthen their institution, maybe beg the lawyers and the NBA to maybe appeal to government to review their policy to increase their scope, to strengthen their institution, and maybe to increase their scope to grassroots level. When you talk about money laundering, sir, common sense tells us that the corporation responsible for money laundering start with multinational corporations, sir. When you look at their activities, Nigerians have lost billions through their activities in Nigeria, through direct looting. At times they take this money out by their ships and by their private jets. We should look at that also with religious organizations. You can't talk about terrorism without the extreme teaching by all these religious organizations on both divides. It baffles me when everything is always limited to judiciary. I've been to the court. You see a case that went for almost 6 months, painstakingly taken. At the end of the day, the person loses. You come to the social space and said judiciaries are corrupt, lawyers are corrupt. It's high time that lawyers should start defending themselves.
Uh, can you hear me, Leonard Sick?
You.
We are back online.
Oh, I can hear you.
Okay, thank you very much.
We're having a few
That's the-
technical challenges, but we have been able to resolve
Yes.
them.
Yes, we noticed that. So that is the only contributor from this end.
Can he repeat? Because we didn't hear him. Oh. We lost him for about a minute, although he was supposed to have been rounding up. We got him in so far as he said there's need to stop passing the buck to the judiciary on this issue of money
Yes,
laundering. There are other stakeholders involved. That was what we were able to get from his presentation.
Okay, I think in summary, that is his contribution. Okay. Just in summary.
Sorry, in summary, what I was trying to say is that EFCC should look into the activities of multinationals in Nigeria. Everybody is common sense that they are the conduit part when it comes to money laundering. We should look into the activities of all the religious organizations that have private jet, that have access to ship. There are times that they launder this money through their ships and some they even convert to drugs and they take it outside. So we should look at it. And when they were mentioning the fact that all these international conventions that this stated this that Nigeria will be sanctioned, I said all the Bretton Woods apparatus and United Nations agency, they don't give a damn about a global south, which Nigeria is among. All they're interested is how to get our money to their banks and keep and use for their own economic resuscitation. The focus is that when a multinational or maybe an international convention says this, we've been part of UNCAC, United Nations Convention Against Corruption, and corruption keep on soaring in Nigeria. Each time they lose this money, they take it to their banks and they keep and they use it for their own businesses to pilot the growth of their economy. So it baffles me when they look at in Nigeria today, there's so much barrage against the judiciary and the lawyers. It's high time you start protecting yourself, sir. Lawyers and they are not the problem of Nigeria. Been to the court whereby I saw the procedure of the case painstakingly taken. At the end of the day, when the person lost, he went to the social media and said the judges are corrupt, blah blah blah, and there should be sanction for defamation. There are times that the judges should also sue if they defame their profession. If not, if you allow these propagandists to continue,
thank you.
Okay, thank you very much.
Thank you very
So
much.
I
I see.
Okay,
Thank you for coming to our aid.
Okay, thank you.
I'm sure the FCC is here as well. I'm sure if you have any report against any specific multinational, you can make them available to them, and I'm sure they will investigate it.
All right, let's see. The contributor from here.
Is that the only contributor you have there, sir?
Yes. Thank you.
All right. So I think we can round up. Okay, please. Do we have another microphone? Thank you.
All protocols duly observed. I'm Commander Okechukwu. Mine is just a basic question. So I want our opinion on this. We're converting lawyers to investigation officers or investigative journalists be more effective in the fight against money laundering and the corruption in Nigeria when you consider all the measures already in place? For instance, the linking of BVN to NIN, introduction of withdrawal limits, and everything that is already in place by the government towards fighting corruption and money. So also imposing all these tasks on lawyers, do we think that it will be more effective? So why go into it? So in my own opinion, I feel that there's actually a need to also review this RPC and the MLA Act, with a view to incorporating all the observations that especially the first speaker raised in his presentation towards making effective amendments to those documents. Thank you.
Thank you very much. I think we are running out of time because we know we have another session in the afternoon. So I will hand over to the chairman to close the session. Okay, I will now invite the lead speaker for a response to the questions, and then any of the discussants to give their final thoughts in a minute or two. So I'll start with the lead speaker. Okay. So let me start. Let me. He has elected to go last. So let me start with Arome. If you have, if it is.
Okay. My simple response to that question is that it is not every dealing between a lawyer and his client that is required to report to the NBA for onward transmission to the NFIU. It is after risk assessment has been carried out by the lawyer, not in every situation. After risk assessment has been carried out by the lawyer, it is at that point that the reporting obligation to the NBA and for onward transmission to the NFIU arises. So the RPC still guarantees internal regulation. The fact that lawyers are now required to report suspicious transactions to the NBA AMLC for onward transmission to the NFIU does not mean that the NFIU is now the one regulating the practice of law. So it is after risk assessment has been conducted. It is not based on a financial threshold. Those requirements of that, if it is above $1,000, you have to report. It is no longer there. So it is a matter of internal regulation. What we sought to achieve through the case I filed has still been is still in place. The SCOMOL, the EFCC, the NFIU do not regulate the practice of law. And what we are required to report to the NBA for onward transmission to the NFIU is the suspicious practitioner. Then, if you permit me to comment on the question asked by our colleague about whether lawyers should be conscripted as law enforcement agents. Now, they are under our penal laws, criminal and the penal code. There are rules, there are provisions that if you are aware that a particular person, whether you're a lawyer or not, is trying to commit a crime, if you fail to report that person, you are yourself an offender. It is in our penal laws. So whether you're a lawyer or not, and I'd like to make this final point before I yield the mic. What the chapter 2 of the RPC sought to guarantee or sought to regulate is not just money laundering. It is both money laundering and counter-terrorism financing, which affects each and every one of us, which we can all become victims of. So if you find your client trying to, finance terrorism, and you want to shield that client because of some lacunas in the law, at the end of the day, terrorism is a global concern. So it is not about conscripting lawyers to become investigators. Terrorism affects everybody, and every Nigerian is under obligation to report crime, whether you're a lawyer or not. It is in our penal laws. Thank you.
So I don't know if Leonard Sikaudu Anuga has any contribution. Monday Aje, I don't know if you have any. Okay.
Some of your question. What's the essence of having a particular law that its enforcement is practically impossible? We must be guided before we rush into making laws that are practically impossible in our domain. So the essence of doing that will just be a waste of the public resources. And I want to advise those who are making some of these laws should look back inward and consider the situation we find ourselves in Nigeria and our own peculiar nature before we make some series of law. And that's what we have in Nigeria. There's no every facet of our institution that doesn't have law. But how can we implement executive law? That's the challenges we are facing. Thank you very much.
Thank you. Okay. I will also go to Leonard Silk for his closing thoughts. Silvanus Tair for his Silvanus. So, Yes, Mr. Silvanus from, yes.
Really, I don't have anything to add. I repeat what I have said. Don't be scared. I'm not going to deliver another paper. All right. Before I get to the interventions and questions, I just make one or two comments. The presentation of my learned friend, Abu Arume, who believes that the MLA 2023 is able to coexist with the privileges, obligations, confidentiality and privileges provisions for the lawyer. I agree that MLA 2023 has a lot of comfort in that you are not directly being reported to the authorities. You are not reporting directly to the authorities, but you are reporting to MBA, who are your colleagues, who should be able to look at your transactions with the eyes of a colleague before they go ahead to report it. But beyond that, the issue that needs to be resolved is still whether the provisions of MLA, the 2023 rules are in line with the provisions of Section 2, the 290, the Evidence Act, whether they are in line with the provisions of the Evidence Act. And the answer is most likely to be no. He has also said that it does not apply to every transaction. It relates mainly to suspicious transactions. But I have to draw his attention to Section 61 sub 4, which in respect of assessing risks, it says the following steps shall be adopted by legal practitioners and law firms to minimize money laundering and terrorism financing risks on every transaction they are instructed to carry out by their clients. It relates to every transaction. So you must do that first, then before you decide whether to report or not to report. But you must have your documentation to answer in case an investigation comes back to you to say, this is what I did, and this is what formed my decision to report or my decision not to report. So it does not give the lawyer that type of freedom that may be understood from Arume's presentation. Now, my brother Silk from the EFCC, Chief Tahir himself, SAN, well, you raised a number of issues, and I love the passion with which they were presented. You truly represent us as Nigeria. I doff my hat for you. Now, you talked about global developments and that Nigeria cannot be an island unto itself. I will not be less patriotic by saying that it's high time we start thinking for ourselves as a nation. The idea of being governed by other people's thinking has been with us for too long. So for how long are we going to continue with that? There is a framework, a constitutional framework, legal framework for Nigeria. It is not what was produced by UN that informed our constitution. Now, are we going to trample upon our own constitution simply because we want to key in to those who are telling us they will lend us money only if we comply? Must we continue to go borrowing? These are some of the fundamental issues that need to be resolved. Kenya is also a member of the Committee of Nations. Kenya has said no to these provisions that were recommended by the Financial Action Task Force. They have said no. It has gone to their parliament more than once. And on each occasion, they managed to defeat it. The bar goes into lobby to say we cannot accept this responsibility. It's one of the nations, and it's an African nation. And I'm almost very certain that if you go to countries, although I have not researched it, if you go to countries like China, you may find that they have not and may not be willing to accept such recommendations from European nations or from the United States of America. They'll be forging their own. When are we going to start? But apart from that, the position remains that it does not conform with our constitution, apart from not conforming with our National Assembly made laws. So in those circumstances, the court will eventually speak because they can't keep running away from it. They spoke in Central Bank case. They spoke in Arome's case. Yes, the court spoke in Arome's case. They spoke in Ozokome's case. I'm almost certain that they will speak again. Now, when we say we are lining up with UN because of the ONDOC or whatever it is called, we ask ourselves a question. In respect of the United Nations recommendations, there has to be a predicate offense. In this reporting exercise, what is a predicate offense that the lawyer is looking at that should entitle a lawyer to freeze the account of another person only because the name of somebody appears on a list, and sometimes it could be a mistake. Somebody is spelling Tahi, now putting R to it. It then becomes Tahir. Then you say, because I have seen that name, and for that reason, I must freeze assets that have been handed over to me for a purpose of transaction. No, I don't think that will be right. Our constitution will not permit it. I believe our courts will resist it. And then, secondly, the Legal Practitioners Act is clear as to how the position of, the practice of the lawyer is to be regulated. It does not subject itself to control of United Nations conventions, which have not been made into acts of parliament in Nigeria. And there is nothing there also that can save the court from applying the consistency rule, which is that when a rule which is inferior to an act of parliament is passed, it is the rule that will give way to the act of the parliament. It is also the rule that will give way to the constitution. So I'm sorry to say that I do not agree. But you also talked about those who go outside the duties of the ordinary legal practitioner and get themselves engaged in the role of financial advisors. If you do have them, present them to the LPDC. because the LPDC will not tolerate that. You don't go outside of the professional regulations to constitute yourself into an institution performing tasks that lawyers are not entitled to perform. That in itself is a professional misconduct. So it cannot be the one to be protected by any rule of the legal practitioner's conduct. So in those circumstances, that cannot arise at all. We see situations where lawyers, especially some of the young lawyers, print complimentary cards, and they say they are consultants, financial consultants, estate management consultants, and all that. God bless you. The day you are brought before the LPDC, that will end your consultancy role. In fact, it will open the door for you to go and start doing that consultancy and nothing else. No lawyering work again. So go and open your shop wherever you want to open it and do consultancy work. So it is not something to be covered by the legal RPC. And I don't think that was intended. Then I agree completely with Ajay. In fact, I think I scored 2.5. Ajay and Anuga agreed with me, and Aroma agreed with me by half. So, okay. So, but to just add to what Ajay said, I think the amendments should go beyond just the National Assembly, because there are certain things there that infringe directly on the Constitution. And those ones that infringe on the Constitution will require constitutional amendment. So it's a long road, but we have to engage in it if we so badly desire it. Now, so interventions. My Lord Justice Adamu, thank you very much for your question. Your question was related to Rule 64, which talks about freezing. And yes, that question is a question that everybody will need to ask. Is it to be done in conjunction with the police? I would even ask, is it to be done in conjunction with the police and the court? Should there be an order first before you engage in that? The way the rule has made it, it does not require to be in the conjunction. We would have been happy to claim that power, because that is the power that is reserved for the court alone. As legal practitioners, that somebody submits money to your chambers, maybe you are in need of supporting your child abroad, and then you say, I hereby freeze. I hereby freeze your account. But unfortunately, that is not the right thing to do. Now, the last is the commander, Okechukwu. Will converting lawyers to investigative agencies with all we have made or done, including raising BVN and the rest of them, would it really be the way out? I do agree with you that it is not the way out. We cannot keep pretending that our institutions should be looking for scapegoats. EFCC officials, my learned brother Silk, is being paid fully on a monthly basis. Then he goes on holiday, he's given a holiday allowance. He goes abroad, he's given extra code, and all that. This poor man here speaking to you, I have to crack before I can chew. Any palm kernel that I need to chew, I first of all have to crack it before I pick it up and put in my mouth and chew. I don't have that privilege of being funded by the state. So those who have been paid for the work of the state should do the work of the state. Those of us who are not privileged to be paid by the state, please leave us alone. Thank you very much.
Oh, please another round of applause. I believe you'll agree with me that this session 1 of day 2 has been very lively and vibrant, and starting from the lead presenter and all the discussants, I believe we are all better informed. We've gained a lot. In fact, the way my mind was working, that if I were to be opportune to go back to the bench and I were to write a judgment on this topic, I already have enough materials. So, but at the bottom line is the fact that as legal practitioners, we are trained professionals, and as such, we should ensure that we are not complicit and should not be seen to be aiding and abetting money laundering in any form or shape. Thank you very much for your active participation, Mr. Tom.
Thank you very much. Let's give the chairman, all the panelists, a resounding round of applause. In fact, as they were giving their presentations and rounding up, the coordinator of the Rule of Law Development Foundation joined us, Mr. J.B. DAUDU, Senior Advocate of Nigeria. Please let's give him a round of applause. We also have with us Mr. Ruben Atabo, Senior Advocate of Nigeria, who has also joined us. And I send warm felicitations to our correspondents and colleagues in the glass house, LOKOJA, particularly my lords, Honorable Justice Emi Umar, I salute you. Honorable Justice Salisu Umar, Honorable Justice A.O. Salihu, and Honorable Justice Anwulu, I doff my cap. I hope we have been able to provide you with enough materials in the event that these issues come up before your courts. I send my warmest regards also to the SG, the Secretary, the Permanent Secretary and Solicitor General of the Ministry of Justice, who is Hajia Musa Yusuf Falilat. Ma, you're also welcome. Thank you for encouraging us. All the directors of the Ministry of Justice also there present, all magistrates and your worships that have joined us. We are very grateful to you being here as well. So, in concluding this session, permit me, let's give a round of applause again for this discussion. Let's give them a round of applause. Very, very, very controversial topic. Starting from the lead speaker, he was able to take us on a journey for about almost an hour about the entire salient issues that revolve around this debate between protection of anti-money laundering laws and the right to client attorney privilege. We have been able to hear different thoughts, particularly from learned senior advocate from the EFCC, Silvanos Tahir. We have also been enriched by your perspective. You made a key point which we cannot shy away from. We are first Nigerians before we are lawyers. So we have to look at, there's a social problem of certainly corruption. But whether it is only lawyers that bear the responsibility as Superman to solve the problem is now the issue. We will do our own part. And we heard from Mr. Anuga, despite coming into the conversation a bit late due to his obligations in the court, he was able to give us a balanced perspective. And then Arome Abu as well, who started the crusade last year in ensuring that constitutional rights and the rights of attorney privilege are protected. We also benefited immensely from your contributions. And we cannot forget the contribution of Monde Aje, who gave us a very humorous, realistic point of view as to the issues. Please, let's give them a round of applause again. And I will not also forget to thank the chairperson. Yes, sir. I will not also forget to thank the chairperson. Please, let's give the chairperson a resounding round of applause. He filled in for Leonard Silk, Yusuf Ali, SAN on very short notice, as I told you, and he has been able to steer the ship to where we are. So, we will now be ending with the national anthem, but we will only have 30 minutes for our tea break, where we'll come back precisely at 1:30 where we'll go on the FCT showcase. And the next topic is the FCT as the model for administration of criminal justice. And we have various speakers who are lined up to talk about that. So we are going to tap into a practical analysis of the FCT and what we are doing in the FCT with regards to administration of criminal justice. It will be very interesting. We're also likely to be launching our directions and rulings of the LPDC. So it is likely to be unveiled at this session. I urge us to please stay behind and enjoy and benefit from this session. So the technical, can you please, is there any announcement, any housekeeping? Okay, I understand that the tea break for resource persons will be upstairs, and I'm sure the Secretariat of the Rule of Law Development Foundation will lead our resource persons and our elders to where they will take their tea break. Meanwhile, the rest of us, tea break is, there's a food court outside where we can take our tea break. So technically, if you can cue the national anthem so that we can declare the first session closed, please. Thank you.
Nigerians old and proud to serve our sovereign motherland. Our flag shall be a symbol that truth and justice reign. In peace or battle honored, and this we count as gain. Provide unto our children a banner without stain. O God of all creation, grant this our hungry thirst. Help us to build our nation where no man is oppressed. And so with peace and plenty, Nigeria may be blessed.
Group photographs. Can we have group photographs with the resource persons using the barrier here, using the banner here? We can stay for group photo. Can the photographer come and quickly organize the group photograph for the resource persons? Can the session managers also come and assist with that quickly? I saw a paper. Yes, please.
Help drive sales, leads, or serve traffic by getting your business. Well, you done me, you bet I felt it. I tried to be chill, but you're so hot that I melted. I fell right through the cracks. Now I'm trying to get back. Before the cool done run out, I'll be giving it my best. It's nothing is gonna stop me but divine intervention. I reckon it's again my turn to win some or learn some, but I won't hesitate no more, no more. It cannot wait. I'm yours. Open up your mind and see like me. Open up your plans and damn, you're free. Look into your heart and you'll find love, 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 love. Listen to the music of the moment, people dance and sing. We're just one big family, and it's our God-forsaken right to be loved, love, 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 love. So I won't hesitate no more, no more. It cannot wait. I'm sure there's no need to complicate. Our time is short. This is our fate. I'm yours. Scoot your love closer, dear, and I will remember your ear. Still the bubble. I've been spending way too long checking my tongue in the mirror and bending over backwards just to try to see it clearer. But my breath fogged up the glass, and so I drew a new face and I laughed. I guess what I've been saying is there ain't no better reason to rid yourself of vanities and just go with the seasons. It's what we aim to do.
One love, one love, one love, oh, one love, one love, one love, one love, oh, one love, bring us all together. Oh, one love, bring us all together. One love, one love, one love, oh, one love. One love, one love, one love, oh, one love, bring us all together. Oh, one love, bring us all together. Bring us all together. Oh, one love, bring us all together. Shi de shiku de shikuna haushi. Mure susure ku anafushi. Mukoma baya mantada melefi. Kashanjuna bayede masala. Wanna see Hutus and Zulus, Fulani, Conakry, Yoruba, Jula, Eritrean, Libyan, Dukamu, Mushiria. Nida kaikede ni mutaimaka. Ha! One love, one love, one love, oh, one love. One love, one love, one love, oh, one love, bring us all together. Oh, one love, bring us all together. One love, one love, one love, oh, one love, one love, one love, one love, oh, one love, bring us all together. Oh, one love, bring us all together. Africa unite, say Kwame Nkrumah. Give me the voice of the great Nelson Mandela. Energy of hope like Thomas Sankara. Resilient, defiant like Baba Fela. Musa Chore, Chinachebe Suke Toure. Patrick Lumumba, Gaddafi, Haile Selassie. African unity is all that I see. If you know that we are one family and you throw them stones just to hurt me, don't forget one day when you need me. Turn around, what you see, be burn bridges. So one love, keep us all together. One love, one love, one love, oh, one love. One love, one love, one love, oh, one love, bring us all together. Oh, one love, bring us all together. One love. We keep marching and we no stopping. We keep searching through, we are seeking. We keep speaking till them see reason. We keep marching and we no stopping. We keep searching through, we are seeking. We keep speaking till them see reason. I say, brother man, for $1, don't forget Impala. One love and honesty, that is the guarantee. Unity, liberty, will bring equality, but no security to save humanity. So what's it gonna be to end this poverty? We keep marching and we no stopping. We keep searching through, we are seeking. We keep speaking till them see reason. We keep marching and we no stopping. We keep searching through, we are seeking. We keep speaking till them see reason. Open up your eyes, we are hurting each other. Come together now, make we try all over. Let us find a way where we trust one another. So all them politics, we don't want never ever. So we must take the lead and stop hypocrisy. Backbite and jealousy will cause disunity. We keep marching and we no stopping. We keep searching through, we are seeking. We keep speaking till them see reason. We keep marching and we no stopping. We keep searching through, we are seeking. We keep speaking till them see reason. Association Records, Black Cat Lion straight out of UK. Let's none of this.
Territory. We had indicated that that goodwill message will be delivered today at this session. And so I'll be inviting for the goodwill message. Let's give a round of applause to our own Benedict Daudu, the SSA Legal, to the Honorable Minister for his goodwill message. You're welcome, sir. Stop the music.
Bring us all together.
Good afternoon. The coordinator and founder, Joseph Bodri Daudu SAN, distinguished honorable justices present, senior members of the bar, distinguished guests, esteemed members of the Rule of Law Foundation, esteemed legal minds, ladies and gentlemen. The Honorable Minister regrettably would have been present here, but due to unforeseen circumstances, he sends his apologies on his absence and has asked me to give his goodwill message. And it begins. It is with immense pleasure and a sense of great honor that I extend my warm greetings to JB Daudu SAN, the Rule of Law Foundation, and all of you gathered here today at the 6th Annual Criminal Law Review Conference. As the Federal Capital Territory Minister, it is a privilege to address such an esteemed assembly dedicated to the critical theme, how to navigate emerging and systematic challenges of insecurity and economic hardship. Firstly, I must express my heartfelt gratitude to the Rule of Law Foundation for their relentless dedication to advancing the principles of justice, promotion of the rule of law in Nigeria and Africa, promoting and encouraging legislative advocacy skills within the ambits of the rule of law, for their tireless efforts in promoting legal excellence, for being the driving force behind this pivotal conference. Your unwavering commitment to the rule of law serves as a beacon guiding our nation towards a fair and just society. Our country finds itself at a critical juncture where the intersection of insecurity and economic hardship demands not only innovative strategies, but also resolute commitment to upholding the rule of law. This conference provides a crucial platform for introspection, dialogue, and the formulation of pragmatic solutions to these pressing issues. The Federal Capital Territory, as the seat of government and a beacon of unity, plays a unique role in this national discourse. Our administration is fully committed to fostering a secure environment where justice is accessible and economic opportunities flourish for all residents and visitors. We recognize that the fight against systemic challenges require multi-sectoral approach, anchored on the pillars of fairness, equity, and respect of the rule of law. Once again, I commend the Rule of Law Development Foundation for their consistency in championing these principles of justice and legal reform through initiatives like this. The insights and resolutions that will emerge from your deliberations will undoubtedly serve as a guiding light for policymakers, legal practitioners, and society at large. As you engage in these critical discussions, let us remain steadfast in our collective resolve to address insecurity and economic challenges, knowing that the strength of our nation lies in our ability to confront adversity with courage, innovation, and unity. I wish you fruitful deliberations and a successful conference. May your efforts continue to inspire transformative change in our legal and societal landscape. Thank you, and may God bless the Federal Republic of Nigeria.
Thank you, Benedict. Please give him another round of applause. Ably stepping in for his boss, the Honorable Minister of the FCT. We are grateful for that goodwill message. But even yesterday, there was an assignment which the Honorable Minister was to conduct at the opening ceremony, which we adjourned to today, and is the unveiling of the directions and rules of the Legal Practitioners Disciplinary Committee. The 6th volume will be done at this gathering before we proceed to the next session. So, permit me now to invite the General Counsel to be assisted by the SL. Okay, there's a reviewer. Okay. I understand there will be a review of the book. So let me just call on the review before it is launched. It must be reviewed. I understand that the person who will be reviewing the book is one of our very revered elders, Mr. Anoze Obi, MNI. Please let's give him a round of applause while he undertakes this exercise before we launch the book and unveil it to the public.
Good afternoon, Chairman, ladies and gentlemen. The 6th volume of Directions and Rulings of Legal Professional Disciplinary Committee or the Board of Benchers. It is a compendium of 38 directions covering a total of 610 pages of the rulings and directions. It covers a gamut of issues bordering on the legal ethics and the discipline at the bar. I like to scan through the pages. At page 38 of the directions is one, the direction in the case of Architect George Bolanle and Akinyemi Oware. In that case, the petitioner complained against his lawyer because he did not conduct the case the way he wanted it and he did not manipulate things the way he wanted to do it. The committee resolved that every lawyer charged with a responsibility to handle a case must do so within the bounds of the law, and that the lawyer is not the servant of the client. He must not do what his client wants, but must do so within the bounds of the law. In fact, they quoted with admiration the case of Oboru and Udwanga, where the court said the counsel is neither a steward nor a servant of his client, but stands at the bar as an authority. Indeed, I have Ogumbi JSC at page 557. I have earlier expressed an earlier view that the applicants are introducing a very dangerous trend, which no doubt will subject the counsel to the client's intimidation. This precedent will certainly not augur well for the legal profession, which from time immemorial had recognized the liberty of a counsel to exercise his discretion to act on behalf of his client. The client wanted him to act in a particular way, and when he did not, he complained against the lawyer, insisting that he should have conducted his divorce petition the way he wanted it. And the man said, the legal practitioner held rightly that the legal practitioner has the discretion to act, has a duty to act within the law. So when you handle cases for clients, you must be mindful that they do not make you do things you should not do. In the other direction at page 37 is another case where a client reported another, the lawyer, for not doing what he had directed him to do. He had said he had agreed with the counsel for fees of 100,000. Regrettably, the lawyer did not reduce the agreement on his fees into writing. And the resultant effect was that when he exercised his rights to his fees by appropriating part of the monies recovered, of course, the court held he did not have a right to exercise a lien over his client's money. And that such important matter as instruction of a client should be reduced in writing. I like to say to lawyers, this volume is a very important one for you to go through, because oftentimes people just take it for granted that the person briefing them is their friend, so they don't reduce things in writing. Now, in another matter, in one of the other, in a second case, they also held that it is inappropriate for a client, for lawyers to act as agents, tenancy agents for their clients, because oftentimes lawyers go and act their property consultants, their agents, and in doing so, they go beyond the lines of duty. In page 599, they held that property manager role is a practice incompatible with the practice of legal profession. You can't practice both professions at the same time. You know, it's easy for clients to say, oh, you're my lawyer, manage my property. It's a very dangerous line. You must draw the line. You are best advised to find a suitable estate surveyor and valuer to manage that for you. And across the gamut of the judgments, several important judgments here. Some involve very eminent senior advocates of Nigeria. There's a complaint against Femi Falana in one of the directions. That complaint was that he withdrew a case which he was instructed. In fact, the complaint against him, his wife, his son, and 4 members of his chambers at the industrial court that he exercised his discretion to withdraw an improperly filed application. And the legal presidential committee says the lawyer is the master of his case. And if the lawyer finds that the actions which have been filed, which you are called upon to take over, is not properly done, you have a duty to do the right thing. And no complaint can arise against you for exercising your discretion in that matter. One of our prominent lawyers, former national officer, at page 459, Golden Tamuno, was also disbarred and his name struck out from the rule of legal practitioners for failure to remit clients' funds. Across the whole gamut of these directions are issues bordering on Section 23, management and accounting for clients' funds. You know, it's been set up over and over again and up to time that majority of the matters that come before legal practice different committee are issues that border on lawyer maintaining a client's account and management of clients' funds. You know, oftentimes lawyers believe that they can do magic. The day it will be required of you to do that magic for yourself, your magic will fail on that day. So, one of other direction I want to refer your minds to is one where a council in Anambra State, once he became a lawyer, started terrorizing and harassing his community people with lots and lots of cases. He filed, in the case of Jidofo, he filed several cases against 4 cases against his community members. If you annoyed him, he will slam a writ against you. If you spoke to him, he will slam a writ. So he was now harassing and terrorizing people in his community with frivolous applications and suits. And the legal presidential committee held that that was a professional misconduct. That a man should not, because he's a lawyer, use his position as a lawyer to terrorize others. There's a very interesting one at page 534. A council was briefed to register a trademark by somebody for a firm in Singapore, and they wrote to require him to give an account, to give an update on the work they are giving him. The council replied and told them that for every inquiry Each time they asked him for a report, that they will pay him $480, and he refused to give them updates on the cases that given to him. In fact, he wrote a very scathing text to them, telling them that they had no duty, that they are lawyers, they should know that it takes time for trademark certificates to come out, and that it should not disturb him. And the committee rightly held that let me even read what he said. Hi, short answer, I don't know. They asked him, when will the certificate be? I said, I don't know. Long as I do not know, I will not know, and you ought to know that such is under the sole of the control of registry. When the certificate is issued, we will notify you as usual. I had earlier advised that your unnecessary inquiries and incessant follow-up on this trademark application have been negatively impacting on our time and the billable hours for other clients' matters. Effectively, immediately, we will be responding to any inquiry you might have as regards the above unidentified matters at the rate of $250 per inquiry or $480 per hour, whichever is greater. An invoice shall be created for every advisory or answer you have received from us, and you shall be obliged to settle each and every invoice before the trademark is closed.
Hello? Let's see if you can hear us. We've lost audio here. We can't hear the presenter. In case you can hear us, we've lost audio from here. Hello? It's possible they have ours.
I was enjoying it.
Hello, sir. Hello, sir. We've lost audio here. We can't hear the presenter. Yes, we don't have audio here.
In that case, no, it's my fault, really. In Tido Securities, the lawyer held himself out as a property manager. And the clients required him to give an account of his stewardship. And he retorted that he did not have a duty to account to them, that they were not the persons who instructed him. This is a family property. Some other members of the family required him to give an account. He failed to give an account. And they established that they handed over to him, and that he acted as counsel in the matter, and he was duty bound to account. And because of those infractions, he was disbarred. Now, what's important in this matter is that in this judgment, in this volume, no segment of legal profession was spared. There were complaints against senior advocates, Obi Najoko. There were complaints against Femi Falana. There were complaints brought by Muiz Banire and others. Across the whole gamut of these directions are cases dealing on duty of counsel. Even when counsel acts as receiver manager, he does so while his status as a lawyer, and you cannot, because you are a receiver manager, liquidator, then decline to give an account because you were a lawyer. The lawyer who did that in the case of page 59, Veronica Harbour, was reprimanded by the disciplinary committee and was held liable for not giving an account and was suspended for 2 years. There is another case at page 596 of Veronica Harbour and Victor Eberi Onen. This involved family property. A member of family was given letter of administration. The brother was opposed to it. He hired a lawyer who went to court. While the case was pending in court, the lawyer went to the house, issued quit notices to the tenants in the house, even removed the roof of the house and doors. You would think that lawyer thinks that nobody he's untouchable. He's the lawyer, he's infallible. Well, he earned him the hammer of the disciplinary committee. He was appropriately sanctioned and disbarred. So on the whole, I'd like to say to you, everything you do as a lawyer, qua lawyer, you must remain within the bounds of the law. You must, in handling the briefs of your clients, you must ensure proper documentation of your instructions. You must act within the rules of professional conduct, and you will not go outside the rules to please your clients. You are not the servant of the client. You are his professional advisor. Your duty is to the profession, to justice, and not to pander to the whims and caprices of your client. I recommend this volume to every lawyer. There are 38 decisions on the whole. By the time you go through them, one thing or the other will touch you. You will find out that you have, including going to your client's house to take instructions. One of the directions here, suspend a lawyer for 2 years for going to his client's house to take instructions. You know, there are a lot of big men in Nigeria. When I was a very young lawyer, I had one big Alhaji who was my client. He used to call me to dinner by 11 o'clock. He would call me, Mr. Obi, where are you? And I go to his house. I'll sit down. After dinner, he will start telling me instructions. Oh, I took those instructions. I wish I knew the consequence of what I was doing, because I could have earned myself some serious reprimand. You know, because the instructions you take in those circumstances, you don't reduce it into writing. And those briefs will eventually backfire against you. And you will be defenseless when you did not maintain any documentation memo in your office and you did not keep records of what happened. Oh, he just informed you about dinner and briefed you. That you should not do anymore. Please ensure your clients come to your office to give instructions and reduce every instruction into writing. Because when the case goes sour, you will then know that these persons you are fighting for can also fight against you. I recommend these volumes, excellently written, in the style of the founder of the Rule of Law Foundation. You know, he started this process, he's the publisher of this, and from his directions, this set of LPDC members have continued to follow his style. They have not deviated really. They have tried to mimic his style, and many of the judgments he rendered as chairman, directions he gave as chairman of the Legal Public Steering Committee, and we continue to re-echo. I like to say most importantly, that we should be addressed with our rules of professional conduct. Lawyers should study them carefully and ensure that you operate by the rules. Do not step out of it, because when you are a defendant before LAPDC, you have an idea how hot it can be. I've had the misfortune of defending many lawyers in that situation. It's not a laughing matter, because at that time the lawyer is helpless. All allegations are thrown at you, and you cannot even defend yourself too hard. If you defend yourself too hard, you throw yourself inside the pit. So, gentlemen, this volume is a must-have for every lawyer. I recommend it to all of you, and I ask you to just go through them. You will see, you will see that the law takes seriously issues of clients' funds, clients' money, and the maintenance of client accounts and proper accountability to your clients. There's no other alternative to it. And that will be it. I'll just ask each and every one of you, try and get a copy when it's available. Please read them. If not for your own good, for the direction of those around you and those you are bound to mentor. You know, when I was a young student, Agabi told me something. He said, the right you have over others, forget them. The right others have over you, remember them. So that you have to know, through reading these proceedings, to know how far you can go with people and how you should exercise discipline, diligence, and in the handling of professional matters. This is a must-have. Thank you very much.
Let us give Anoze Obi MNI a resounding round of applause. It is now time for us to unveil this book to the public. This law report, it's a law report properly so called, the 6th volume. And I'll be inviting the Honorable Minister of the Federal Capital Territory, His Excellency, Barrister Yesom Ezonwike, to come and do justice to this. And I will apply that he cannot come and do this alone. I'll be inviting the judges here present, particularly ably led by my Lord, Justice Oredola, to also join and take one copy each. I start with the chief launcher. No sitting judge. Okay. All right. I've been corrected that no sitting judge should launch. So we start with symbolically. Yeah, just to unveil, and then the minister will give us his message. And can I call on the representative of the Honorable Minister to come and pick a copy? Then the General Counsel will be doing that, I understand. But the General Counsel can be supported with Benedict for them to take a copy. Then I'll be inviting Mr. Okala, who is the former chairman of the disciplinary committee, to also support us and take a copy while we just stand there. Can I have some of the Secretariat of the Rule of Law Foundation to clear this place briefly so that we can take a picture with the new journal? Then I'll be inviting every learner sick here to also take a copy. Can we start the process? Can we start the process? We'll be unveiling it here. So I'll also be calling others to come and take copies. Yes. I understand that the cover price, due to increased economic hardship, cost of printing, is now 100,000 naira for 38 decisions of the LPDC. Over 610 pages with editorial and finally the state. So at this point in time, no, don't carry, just let them pick one. To where they are. They can. And the forward, yes, the forward was actually written by no other person than the Chief Justice of Nigeria, who, one of her first, I personally went to see her together with Daudi, the SAN, and she would have been here to do this, but for our office. So I'll be calling on the representative of the minister to pick one. Please give him one copy. Can you give me one copy? Before he says something, I wanted everybody to pick. Yes, and then he will then say something. Then, so, can my Lord also pick one? Can one be given to my Lord? Give them, be giving them. Quick. Give Leonard Senior Advocate, Mr. Okala, one. Then I can also call the retired justice. I can see Justice Ajile here. Justice Ajile, I'll be inviting you to take a copy. I'll also be inviting Ruben Atabo, SAN, to also come and pick a copy. Abla Yaya SAN to also come and pick a copy. No, it will be a treasonable offense if I do not call the Abla Yaya SAN. So, and I noticed that for gender balance, we are not balanced gender-wise. So I'll be calling on the chairperson of Banner branch to join them in this exercise. And I'll also be joining our commander, seated right next to her, to also come, pick a copy. I hope our paparazzi and photographers are ready to capture this very epoch-making event. So at this point in time, I hand over to His Excellency, the Honorable Minister of FCT. Yes, certainly. In fact, Abdul, we are supposed to also do the same thing in LOKOJA. I will get back to you very soon.
Okay.
Yes. Abdul, please, LOKOJA, they are not exempted, though. So, please let us hear from the minister. Please.
Yes, my lords can hear you clearly.
So I'll be handing over the microphone to the representative of the minister. I'm here. Yes. Yes. He is representing the minister today. He has that mandate. I'm a mere appointee of the honorable minister. So, yes, I'll be handing it over to him.
The General Counsel is just trying to avoid getting into trouble. So, on behalf of the Honorable Minister, I start by congratulating the Chief Editor-in-Chief, Joseph DAUDU, on this profound book. The directions and rulings of the Legal Practitioners Disciplinary Committee of the Body of Benchers, September 2022 to February 2024, Volume 6. So on behalf of the Minister, I hereby unveil this book and also pledge a certain undisclosed sum to be communicated.
Let's now start with my Lord. We have a retired Justice of the Court of Appeal here. If he wants to say something on the book, he is free to do so now. If the technical can also help me, I can see a mic next to my Lord, so that then Mr. Okala can gear up afterwards, and we'll go in that direction.
standing and remaining on established protocols, and having due respect and love for books, knowing the monumental works that went into producing these directions and rulings, though retired, well, about to be tired. So I'm happy to unveil without launching, but donating an unspecified amount.
Thank you very much. I hope Mr. Okala will not give us an unspecified amount. You should not worry.
No,
I will defend him personally. If there's
Thank
any
you
issue.
very much, MC. I thought you invited me to come and take a book. I have taken one. So can I formally report I have taken one? Well, I know that a lot of effort goes into this, but the joy that we have from it is the fact that it makes available what most lawyers hardly have time to go through: the rules of professional conduct. It's always kept somewhere in the shelf where it is hardly ever noticed until you run into trouble. That is when you realize that they are useful. But with these publications, and as voluminous as they are, I'm sure they will occupy prominent spaces on your shelves and therefore force your attention into reading what has made your friends to fall from glory, so that it will not happen to you. As most of you say in Nigeria, it's not my portion. It will only not be in your portion if you learn to abide by the rules. Having said so, on behalf of myself and His Lordship, the retired Justice Oredola, who has picked a copy, I'll be requiring an extra copy to be delivered to my office. We are taking the copies we are taking for the price of 20 copies. Thank you.
Thank you very much. The price of 20 copies for 2. So my Lord is already with his copy. My Lord is already with his copy. One more. For the price of 20. So those of us that can work, each one is, so if you do the mathematics.
No.
So I'll be calling on Mr. Ruben Atabo,
the founder of the Rule of Law Development Foundation, my leader, my president, J.B. DAUDU. I know a lot of
Doctor, sorry, so sorry. So sorry. In fact, I'm about to start my own, so I know it's difficult.
My leader has been a father and has been a mentor. I remember when we did the controversial case, INS International Limited, Abdul Bello Hill, the judgment of the Court of Appeal delivered on the 14th day of December 2004 by the Court of Appeal. So he has been a father, and I know a lot of work has gone into this. I'll pledge for an undisclosed amount. I'll get the account number from the secretariat.
Thank you,
Thank
Leonard
you.
Sik. Thank you, Leonard Sik. Thank you, Leonard Sik.
As has been said, a lot of work, just looking at it and knowing the editor-in-chief, you know the amount of effort and work that has gone into this. I won't be breaking protocol. I will take this copy for an undisclosed amount, which will be remitted into an account to be so designated.
Thank you very much, Leonard Sik. Can I also invite my Lord to say something? Justice Ajile, retired, to also say something before I get to our chairman and Commander here before we round up.
The coordinator of the Rule of Law Foundation. Well, I am part and parcel of the foundation, and I will never forget the role the foundation played at the time of my retirement. And well, before I make any further announcement, the book was ably reviewed, but in the course of the review, it's like I had a confession from somebody, and I want to ask him, or I want to ask the floor here, whether time runs against infraction. Anyway, that's by the way. Whatever is the cost of a copy, I will pay and take. Thank you.
Thank you very much, sir. Can we hear from the chairman of Banawa branch? Chairman, she's here. She's right here.
Just like my daddy here, I would not want to break the protocol. The coordinator is my father, and so I will also take the book for the cost of the price. Thank you.
Thank you very much.
Good afternoon, everyone. In the Nigerian Navy, we usually make a lot of requests, so I request to stand on an existing protocol. I'm not here in my personal capacity. I'm here on behalf of my boss, but I know that he will appreciate this book, the importance of this book, especially with respect to the lawyers in the Directorate of Legal Services of the Nigerian Navy. So I'll be accepting this on his behalf for an undisclosed amount too. And I know that the Nigerian Navy will equally request for more of this because we would like to distribute to the various commands. So you'll be hearing back from us.
Thank you very much. We can all take our seats. We can all take our seats. I have stressed and strained you a bit. Thank you so much for performing this exercise. I don't know whether Abdul in LOKOJA will have any message. Do we have any comment on the
None for now.
None for now?
None for now.
Okay. I'm sure in the course of the conference, we still have 3 more days. We'll be hearing from LOKOJA. Yes. We are sending your copies directly with the first vehicle to LOKOJA after this program.
That's okay, sir.
Thank you very much.
All right.
So, is to move to the business of the day, and we are immediately starting our next session. We promise that we will definitely do our best not to take our time with regards to this session. I understand the lead presenter, Professor Benedicta DAUDU, is to present a paper, and the topic is Federal Capital Territory, Abuja, as a model for crime fighting in Nigeria. Evaluation of crime rates in the FCT, a discussion on prevalent offenses, demographics of offenders, policing, administrative, legislative, and judicial intervention in the FCT. This is a very, very, very important topic. I do not mince words in saying that as one of the chairmen of branches, I had the cause to comment on the security situation in the FCT early this year, particularly on the issue of violent crimes. You agree with me, in the FCT, there has been an upsurge in the issue of violent crimes, particularly the popular attack in commercial vehicles called One Chance, where members of the audience will have at least one person they know or have heard of somebody who has fallen victim of one violent crime or the other. We also are having issues not unrelated to the situation FCT finds itself. FCT borders about 4 or 5 states and it is, especially the boundary areas, are prone to certain security challenges that are peculiar. So we are now looking at FCT as a crime fighting model. We have with us here the representative of the Honorable Minister of FCT, who is also the SSA leader. We also have with us Professor Benedicta DAUDU. Can I confirm? I've not seen her physically here. Is she online? Hello, Prof. Prof, can you hear me? Hello? I can see she's on. So, and we also have, we're scheduled to hear from the Commissioner of Police, FCT Command. Do we have the representative of the Commissioner of Police, FCT Command here? Because it would have been important to hear from the police on the issue of crime fighting. You cannot talk about policing, crime fighting without them, but I'm sure we will hear from others. We also have on this panel Mr. Salman Dako, the General Counsel and Secretary Legal Services of the FCT. Let's give him a round of applause. We were also supposed to hear from a Chief Magistrate from the High Court of FCT. I'm not sure there's anybody from the magistracy here present. If there is, please contact us. We also have the Assistant Director, Civil Litigation of the NDLEA, Mr. John Torilla Atsege. Is he here, sir? Please give him a round of applause. He will be speaking to us. Then we have Ijeoma Mary Amugu of NAPTIP. Is she here? Yes, please give her a round of applause, please. Do we have any representative of the Legal Aid Council? I'm not sure we do. And we also have Rebecca Emmanuel Balami, Program Officer, Partners West Africa. Is she around? Please, let's give her a round of applause, please. So, we only have one lead presenter, and we will start with the lead presenter, who will be taking us for 30 minutes, and then I'll be calling on other panelists from time to time. So permit me, if your hands are not busy, please let's give a round of applause to Professor Benedicta DAUDU to give her own take on the topic. Ma, the floor is yours. You can present to us. Thank you. Technical? Hello? It's very faint in the hall. It's very faint. Technical, can we resolve this problem? It's very faint. It is extremely faint. I can hear you, but it's faint. We cannot hear you in the hall, but I can hear you because I'm near the speaker. I think while we are waiting for her to come online, we may need to resort to taking other interventions. And unfortunately, the person I wanted to call has stepped out. Technical, is there any way we can resolve this issue? If not, I'll be calling on the General Counsel and Secretary Legal Services of the FCT, because I know he has a robust presentation. I think let me take him first while we'll sort out the technical challenge to open the floor in terms of discussion. So, sir, I don't know whether you want to speak from here or from where you are. Okay, so you are welcome. Let's give him a round of applause. That is the General Counsel and Secretary Legal Services.
Good afternoon, all. My able leaders at the bar, in the person of Mr. J.B. DAUDU, SAN, former president of the Nigerian Bar Association, and former chairman of the LPDC. I recall those days that whenever we hear of the LPDC, we definitely know that it was a very terrifying place to be. And we've heard a lot of things that happened over there to some of our colleagues. Here today, we also have a former chairman of the LPDC, also, Mr. Emmanuel Ukala. He was here with us shortly. Other distinguished members present. Please permit me to stand on existing protocol. I have here with me, I was saddled with the responsibility of evaluating crime rates in the FCT, prevalent offenses, offenders, demographic, and multifaceted intervention. I think I'll dwell mainly on the prevalent offenses in the FCT, the demography, and the multifaceted intervention, what the FCT administration have done so far in order to curtail some of these crimes. One thing that I believe that everybody here will accept or will agree is that before this present administration, we experienced surge in crime, a whole lot of them, especially the issue of, carbon offenses, carbon robbery, what is popularly known as the one chance, and many other offenses in the FCT. But with the present administration, the Honorable Minister felt that it was part of the essential mandate of his administration to ensure that, security is guaranteed. And as such, there have been, the minister has specific, specific programs to ensure that, the crime rate is brought down to the barest minimum, because we must accept the fact that it is quite very, very difficult to eradicate crime completely in any society, but we must bring it down. That is the mandate every government has. Now, first of all, I want to list out the prevalent offenses in FCT. But before then, I would like to differentiate. I would like to make a clarification, because in my presentation, I'll be making reference to FCT and FCC. There's quite difference. When you talk about FCT, you're talking about Abuja as a whole, the geographical location as defined in the Constitution that comprise the Federal Capital Territory. But when you talk about FCC, it's quite some limited area, especially the cadastral zones from A to E. You talk about places like Asokoro, Wuse, Gwarinpa, Gariki, Maitama. So once I refer to FCC, I'm not talking, and those are the major areas. I'm not making reference to Kwali, but once you hear FCT, it includes the area council. So we're talking about crime rate. The crime rate, the prevalent offenses in the FCT, in the fringes, are quite different from what you have in the FCT. So we have vandalism of critical assets and infrastructure, banditry, rape/assault, human-centered induced communal clashes, cattle rustling, culpable homicide, drug peddling and related offenses, possession of illegal firearms, armed robbery, car snatching and theft, burglary, fraud, forgery, impersonation, murder/assassination, kidnapping and abduction. Yes, there might be other crimes, but these are the prevalent ones. Now, what are the demographic of offenders? The referred crimes, or the listed crimes, are mostly perpetrated by jobless youth. We know that crime takes energy and intellect sometimes to commit, majorly energy to commit. It's quite very easy for somebody who is not thinking well